Right now at 4:30, a man is suing Walt Disney Parks and Resorts for the alleged wrongful death of his wife. He says she died after eating food with dairy and nuts despite telling the staff about her severe allergies. The lawsuit says the restaurant didn't have proper safeguards, but now there's a new legal hurdle after Disney pushed to throw out the lawsuit, all because that same man signed up for a 1-month trial of Disney Plus back in 2019.
Chief Legal Analyst Khalif Rhodes joins us now to break this down. Khalif here, the court documents show that this is really because the company wants the case dismissed because of the fine print in the contract for the subscription service that has nothing to do with the park.
I'm all over this one. Let me say for a couple reasons. As a parent of 4, obviously, I got little kids that love Disney Plus. I mean, they're like, hey, send me the password. Can't get on there, right? Did not know when we signed up that we were also, removing our right to do a jury trial because of the arbitration agreement that's in the clause of the fine print that I clearly didn't read when I was clicking as fast as I could to get that thing installed. But what I can tell you is it makes sense that they're one company. If that language is in there and they're saying, you've agreed to this language against us as a company, you signed this agreement, you should not be able to take this to trial by skipping over the administrative process. Specifically, normally it's either mediation or arbitration. Mediation is not binding. It's you go there, they talk about it, they make an offer, and you can say, you know what, I don't like it, I want to go to trial. But no, in this language it says arbitration, which means the arbitrator will make a decision. Now, do I think a court will say that you have signed away your right to a jury trial while getting in the app? I don't think so. But I can see this language typically in other places. If they were attempting to sue for the app causing some harm, somehow the app burned their house down, or the app did something unfortunate to the person, caused them some type of harm. By all means, I think Disney has a great argument, but I think this is a long shot for sure to say it includes all Disney entities total. I mean, Disney at one point owned ESPN. I mean, so it's extremely like going down a deep rabbit hole.
Grasping at some straws here. Obviously, the lawyer for the family just calls this argument unfair.
Unfair, I mean, is an understatement. He said this is preposterous, like no one thought that they were giving up their right. I mean, and you got to look at this. Not only am I in this case in my mind like all over it because I have small kids. I have small kids with allergies, peanut allergy, shellfish allergy. And so I am in this situation that this woman was in when she went to this restaurant. Clearly called the restaurant to see if they had an issue with allergies. The restaurant said, we can take care of you. And then she was a medical doctor and still died from an allergy. I mean, I'm carrying an EpiPen all around. So I could truly understand what they're going through. And then to say now you know that you've caused the death and you're telling me that not do you want my case dismissed, but I mean they're calling it idiotic that I even filed this claim because I failed to read the small print that 99% of people don't read. In law school they tell you, look, you see these agreements, no one's reading them. If you want to do the activity or you want to download the product, you're either going to say yes or you're going to decline, and then you won't get to do whatever you're trying to do. And so we all go in by circumstance without ever reading them. No one anticipated giving away their rights, or at least their potential right to have a claim. In this situation, a terrible time to find out that that's what you've attempted.
It doesn't come across in good faith, and it's not a good PR move for Disney the way that comes across with everything. But also too, as a lawyer yourself, put yourself in Disney's shoes as a lawyer for them. Why would you put something like this in a contract that says that protects them on something completely different than the subscription service?
If you could put it in there and get away with it, that's the first thing I'll say. I mean, is what you're attempting to do is this is not confrontational. When you're drafting these agreements, when you're drafting this legal language, you're drafting it, and that person, the user, the end user, has an opportunity to say, you know what, I want to sign it or I don't want to sign it. No one is saying, well, let my attorney look this over before I agree to it. So it's already kind of unbalanced, right? But then if you're on Disney's side, you need to form some defense, right? And so they know they'll have a better opportunity with an arbitrator than going to a jury of their peers. You get a jury of your peers, put them in a box. They look at these facts. They're going to give the mountain for punitive damages. An arbitrator will be more level-headed, and that's why they want this to go to an arbitrator for sure.
All right, well, we'll see what happens with this, but very a unique case here, Khalif, for sure.
I would call it shady.
It's super shady.
Yeah, that too.